Entering a home without a judicial warrant is a clear violation of Fourth Amendment unreasonable search and seizure.
Is setting a bar not just for Anaconda, not just for Montana, but for the whole country.
An incident that occurred in a residence on this street in Anaconda 5 years ago was recently scrutinized by the United States Supreme Court.
And you want to ask, did police get the wrong house?
There's movement on this window right here.
They need to be able to look through the window and see him with a gun pointed to his head, or they need to see a dead body on the floor. What more did they need?
The Supreme Court has heard oral arguments in Case versus Montana. It's a case tied to the Fourth Amendment.
It's a good decision for law enforcement because it makes sense, it makes our job a little easier, and it makes it so we can protect citizens.
The ultimate protection you thought you had inside your own house just vanished in a unanimous 9-0 ruling by the Supreme Court of the United States. Right now, law enforcement officers across America possess a federally approved legal bypass that lets them cross your threshold, push past your locked front door, and enter your home without a warrant, all under the legal definition of an emergency aid exception. This ruling doesn't just tweak minor legal procedure, it directly redefines the boundaries of the Fourth Amendment, the constitutional shield that has protected private property from government intrusion for over 2 centuries. If you believe your front door acts as an absolute barrier against warrantless entry, the nation's highest court just delivered a reality check that every property owner in America needs to understand. To see how this legal shield was rewritten, we have to look at the escalating crisis that triggered this Supreme Court battle. A quiet suburban call that descended into bloodshed in a matter of minutes. The 40-minute standoff. The entire legal showdown traces back to September 2021 in Anaconda, Montana. A 911 call came into local dispatch from the ex-girlfriend of William Trevor Case, a former Army veteran with a documented history of mental health struggles and severe alcohol abuse. During a chaotic phone conversation, the caller reported hearing a sudden metallic clicking noise, a sound she recognized as the distinct racking of a pistol slide, followed by complete silence. Before the line went dead, she warned dispatchers that if police officers showed up at his house, he threatened to shoot them all. 4 responding officers from the local department arrived at the residence, treating the call as a welfare check on a potentially suicidal individual. When they pulled up, there was no active gunfire, no screaming, and no immediate signs of physical violence. The officers surrounded the perimeter, peered through the windows, and noticed a disturbing scene. Empty beer cans littered across the tables, a notepad lying on a desk that appeared to be a suicide note, and an empty handgun holster resting in plain view. Yet despite what they saw through the glass, the officers didn't rush the door. They stood outside the residence for over 40 minutes. During those 40 minutes, the responding squad debated their next move. Body camera footage later revealed officers expressing doubts, openly questioning whether Trevor Case was actually in physical danger or if he was simply setting a trap. They considered calling his family members. They considered placing a direct call to his mobile phone. But instead of pursuing those options or contacting a magistrate judge to request an emergency search warrant, the officers made a tactical pivot. They retrieved heavy ballistic shields and high-powered rifles from their patrol vehicles. Finding the front door unlocked, they turned the knob and pushed inside without a warrant. What happened inside the bedroom? The tactical team moved floor by floor through the home with weapons raised. As they reached the upstairs master bedroom, the tension inside the house hit a boiling point. Without warning, a closet curtain inside the bedroom jerked open. One of the officers spotted Trevor Case standing inside the dark closet, his arm extended outward holding what the officer described as a dark metallic object. Believing Case was pointing a handgun directly at him, the officer panicked and fired his weapon. The bullet tore through Case's arm and plunged into his abdomen. After Case was dragged from the room, bleeding and critically injured, officers searched the space and discovered a firearm resting nearby in a laundry basket.
What's it take for an officer to determine there's an emergency and then enter into your home without a search warrant?
The decision it came to will have a national effect.
What is it where a police officer would not have probable cause but can satisfy the Brigham City standard?
Case survived the gunshot wound, but the state of Montana immediately hit him with severe criminal charges, including felony assault on a law enforcement officer. That indictment set off a massive legal battle. Case's defense team filed an aggressive motion to suppress all the physical evidence seized inside the residence. Their argument was straightforward. The police officers had violated the Fourth Amendment by entering his private home without a warrant or probable cause of an active crime. When the trial judge denied the motion, case appealed all the way to the Montana Supreme Court. In a sharp 4-3 split decision, the state high court ruled against Case, inventing a controversial legal test. The state court declared that when police act in a community caretaking role, they don't need probable cause. Instead, the court argued that officers only need a lower threshold called reasonable suspicion, the same basic standard used for a brief traffic stop on a public road to kick open a private door in an emergency. Determined to challenge that precedent, Case took his fight directly to the United States Supreme Court in Washington, D.C. The clash at the Supreme Court. When the case reached the Supreme Court under the official docket, Case v. Montana, it sparked a massive constitutional battle. On one side stood Trevor Case, arguing that the Fourth Amendment demands a strict, unyielding standard of probable cause before police can cross a residential threshold, even during an alleged emergency. He pointed directly to past landmark rulings like Caniglia v. Strom, where the Supreme Court explicitly struck down broad, unregulated community caretaking excuses used by police to search homes without warrants. On the other side, a powerful coalition lined up against him. Both the state of Montana and the United States Department of Justice stepped into the courtroom to fight for expanded police powers. Federal government lawyers explicitly urged the justices to adopt a flexible sliding scale approach under their proposed framework. Whenever an officer suspects a life-threatening scenario, the traditional warrant requirements of the Constitution should dissolve, giving police broad discretion to bypass the Fourth Amendment based on mere reasonable suspicion. When the justices handed down their ruling, the result was a unanimous 9-0 decision, a total shutout that sent shockwaves through the legal community. Writing for the court, Justice Elena Kagan completely demolished the argument put forward by the government and the lower Montana courts.
This is when you can go into somebody's house when you think there's an emergency situation going on.
The Supreme Court flatly rejected the loose reasonable suspicion framework, calling it dangerous and far too weak to guard the sanctity of the private home. The High Court clarified that lower courts cannot water down constitutional rights by inventing loose caretaking loopholes. The hidden reality behind the ruling: while the justices crushed the government's attempt to establish a lower reasonable suspicion standard, they also rejected Trevor Case's demand for strict probable cause. The court ruled that the standard probable cause metric is strictly built for investigating criminal activity, not for quick, life-saving interventions. Instead, the Supreme Court formally reaffirmed and solidified the standard established in the 2006 case Brigham City v. Stewart. Under this doctrine, police officers do not need a warrant or probable cause to cross your threshold. They only need an objectively reasonable basis to believe that an occupant inside is seriously injured or facing imminent physical harm. Applying that test to Trevor Case's situation, all 9 justices agreed that the officers met the threshold. The emergency report of a gun clicking, the threats against responding officers, the empty holster in plain sight, and the total lack of response from inside the house gave officers an objectively reasonable foundation to enter and check for an injured person.
Then inviting a carte blanche to say, don't think of more reasonable way or manner to enter.
Hello? Hello?
An officer may enter a home without a warrant if he has an objectively reasonable basis for believing that an occupant is seriously injured or imminently threatened with such injury. Justice Elena Kagan, writing for the unanimous Supreme Court in Case v. Montana. The critical concurrences. While the 9-0 ruling affirmed the conviction, critical concurring opinions from individual justices exposed the double-edged sword hidden inside this standard. Justice Sonia Sotomayor issued a pointed concurring opinion targeting the dangerous reality of modern welfare checks. She highlighted how wellness checks involving mental health crises frequently escalate into tragic police shootings, the exact outcome that occurred in Trevor Case's bedroom. Sotomayor warned that entering a home with drawn weapons during a mental health crisis can often create the very emergency officers claim they are trying to prevent. Justice Neil Gorsuch filed his own concurrence, hammering home a strict constitutional warning. Gorsuch emphasized that the emergency aid doctrine is exclusively limited to preserving human life. It is not an open invitation or an excuse for law enforcement to conduct general criminal searches. The moment an apparent physical emergency is resolved, any further search of the premises without a freshly issued search warrant becomes an illegal, unconstitutional search under the Fourth Amendment. What this means for your property rights. The ultimate takeaway from Case v. Montana creates a massive evolving battlefield right on your doorstep. On paper, the Supreme Court closed a dangerous loophole by preventing lower courts from using weak reasonable suspicion standards to authorize home entries. But in practice, the ruling firmly establishes that an unverified 911 report, combined with circumstantial observations outside your house, like an empty holster or an unanswered knock, gives law enforcement the ultimate federally approved green light to breach your door without ever speaking to a judge. This ruling solidifies a precedent that will shape property rights and police encounters for decades. It places the burden of proof squarely on individual homeowners to challenge whether an officer's belief was objectively reasonable after the door has already been breached. That's it for today, folks. See you in the next video.